Welcome, y'all. I am the Loud Little Ducky. We have finally have the ruling on Owens and Gingras wanting a new judge and a new trial because everything was so biased. It is denied, but let's jump into why this judge says no. You're not getting a new judge. You're not getting a new trial. You can proceed with appeals now. In the lead judge and Judge Mata, the ruling stands. And now we just wait for appeals if appeals are going to happen. And I think they'll be sticking even after that. Sorry if some of these are hard to read and it's a little blurry. I hope it's not too blurry, but if it is, I am going to be reading it to you. So here we have on 8/14/2024 at 8 a.m. First thing this morning, Superior Court of Arizona in Maricopa County, the Honorable Judge Rhonda Fisk, in the matter of Owens v. Echard, with Gingras and Woodnick and Deandra, Judge Fisk, and Judge Mata. Minute entry. The court has considered petitioner Laura Owens' notice of change of judge for cause, memorandum and affidavit of support, hereafter the Rule 6.1 motion. Well, at least it's not Rule 26. And the separate affidavit of David S. Gingras in support of petitioner's notice of change of judge for cause, hereafter the affidavit, both filed on July 8, 2024, and respondent Clayton Echard's response to notice of change of judge for cause, filed July 11, 2024. Pursuant to Rule 6.1 Arizona Rules of Family Law and Procedure, the Rule 6.1 motion was referred to the Family Department presiding Judge Rhonda Fisk, this court for ruling. See footnote 1. For the reasons set forth herein, the Rule 6.1 motion is denied. So she doesn't even make you read through all this. She is telling you right from the beginning, this is denied. Footnote 1 says, the ruling 6.1 motion was filed after Judge Mata's June 17, 2024 ruling, filed June 18, 2024, and days before petitioner filed various post-trial motions. Judge Mata prematurely ruled on the post-trial motions. That ruling was withdrawn via and July 19, 2024 minute entry ruling filed 7/23/2024. Now that this court has ruled on the 6.1 motion for change of judge, Judge Mata may rule on the pending motions. Well, the ruling is going to stand. She's just going to resubmit what she already wrote, and those are denied. CEG Rule 6.1 D5. If the court determines that the party who filed the affidavit is not entitled to a change of judge, the named judge may proceed with the action. So go ahead and put that ruling back out, Judge Mata. We will not be covering it the second time. We know what it says, unless there's something new in it. Petitioner's Rule 6.1 motion seeks to disqualify for cause the assigned family court judge, Judge Julie Mata, on the basis of bias and prejudice within the meaning of ARS 12-4095. See Rule 6.1 motion at 2. Specifically, petitioner alleges that Judge Mata purportedly did the following. 1. Performed an independent investigation into the facts of the case, and in doing so considered and relied upon information posted on the internet about the case. And 2. Engaged in ex parte communication regarding the case with her father, Harry Howe, who appeared at the trial as a spectator. See Rule 6.1 motion at 1, 12, see footnote 2. So footnote 2 says, the Rule 6.1 motion alleges that these two actions separately violated Rules 2.9a, initiating, permitting, or considering ex parte communications outside the presence of the parties or their lawyers, and 2.9c, a judge shall not investigate facts in a matter independently of the Arizona Rules of Judicial Conduct. It is not for this court to determine whether Judge Mata has violated the Arizona Rules of Judicial Conduct. Moreover, the Rule 6.1 motion makes vague allegations of violations of petitioner's right to due process of the law under both of the United States and Arizona constitutions. See Rule 6.1 motion at 111. Again, it is not within this court's purview to determine whether Judge Mata made errors in her findings of fact and or conclusions of law that violated due process and or warrant a new trial. So this is something that they can't rule on. This is something that the appellate courts are going to have to rule on, which a lot of this was to prepare for the appeals, because he thinks he can win on appeal, because he didn't see any of this going his way. But he's hoping that the appellate team see it his way. I don't think they're going to, but that's just me. Going back up and continuing, as a threshold matter, this court apologizes to the parties for the delay in issuing this ruling. The court had technical difficulties opening the compilation CD included with the affidavit. When opened with Windows Media Player, the file entitled produced an error message. We can't open Judge Mata's dad's compilation. It uses unsupported encoded settings. With technical assistance, the court finally was able to open and review the compilation CD using VLC Media Player. After reviewing the CD, the court prepared this ruling. 1. Timeliness of Rule 6.1 motion. Respondent contends that the Rule 6.1 motion is time-barred under ARS 12409B5 on the basis that it was filed after final trial and final judgment under Rule 78. See response at 4. This court finds that the analysis as to timeliness is more nuanced than respondent suggests. A Rule .61 motion for change of judge for cause must be filed within 20 days of discovering that grounds exist for change of judge. Rule 6.1c of the Arizona Rules of Family Law and Procedure, this court must at least consider the factual allegations to determine whether they are time-barred. The Rule 6.1 motion and affidavit alleges as follows. Judge Mata held an evidentiary hearing on June 10, 2024. Thereafter, the June 10th hearing, see Exhibit E to affidavit, Judge Mata's father, Harry Howe, attended the June 10th hearing as a spectator and spoke to other people in attendance. See affidavit 66 through 67. Individuals Dave Neal and Megan Fox, among others, live streamed and posted on social media various interviews with people who spoke to Mr. Howe at the hearing. CID and accompanying compilation CD on or about June 17, 2024 at 10:10 a.m. Petitioner's Counsel emailed Judge Mata's division and Respondent's Counsel that the statements made on social media had just come to his attention and warranted a change of judge for cause. See Exhibit A to affidavit. At 11:58 a.m., Judge Mata's division sent a response email instructing counsel to file an appropriate motion to bring any issue to the court's attention. See Exhibit B to affidavit. On June 18, 2024, at 8 a.m., Judge Mata's June 17, 2024, under advisement ruling was filed. Hereafter, the June 17th ruling. See Exhibit C to affidavit. The June 17th ruling contained detailed finding of fact, including the following finding. Dr. Samantha Deans further testified that Planned Parenthood is not open on Sundays. When petitioner testified, she sought care July 2, 2023. ID at 10. The trial transcript from June 10th hearing reflects that Dr. Deans did not testify that Planned Parenthood is not open on Sundays. See Exhibit E to affidavit. Based on the foregoing, the court finds that the Rule 6.1 motion filed on July 8, 2024 was timely filed. In making this finding, court acknowledges that within 20 days of the 6/17/2024 is Sunday, 7/7/24. Given the circumstances of this case, including the fact that petitioner's counsel was previously disclosed on a previously disclosed vacation from June 10th through the 28th of 2024, the court finds that the filing of the motion on the next business day, i.e. Monday, July 8th, 2024, was timely. So they do not agree with Woodnick on that it was untimely. They are agreeing with Gingras that it is timely. He submitted it as soon as he could. Now, maybe had he not informed the court about his vacation and stuff like that, maybe it wouldn't be. But, you know, a lot of us think that if he could send this email, he could have submitted this. He found ways to be on the internet during his trip. The affidavit also details various facts and rulings that the petitioner's counsel alleges constitute a summary of pretrial judicial bias. See affidavit at 9 through 12, 37 through 51, and a summary of judicial misconduct and bias at trial, ID at 12 through 15, paragraphs 52 through 64. See also Rule 6.1 motion at 13, alleging Judge Mata manifested clear prejudice and or bias early in the proceeding in the form of multiple unexplained adverse ruling. The court finds that these events that petitioner contends constitute misconduct and bias occurred and were known to the petitioner more than 20 days before she filed her Rule 6.1 motion. The court will limit its evaluation of Rule 6.1 motion solely to the two allegations identified in the second paragraph of this ruling. So all of those bias things that they're saying she did with those previous rulings, he should have said something way before now. So she's not even considering those. That part is untimely. Number 2, request for hearing. Petitioner has requested that this court hold a hearing and order subpoenas ad testificandum for Judge Mata and Harry Howe. A presiding judge review a Rule 6.1 motion for a change of judge as a matter of right as discretion as to whether to hold an evidentiary hearing. See Rule 6.1d(2). The presiding judge may hold a hearing to determine the issues raised in the affidavit or may decide the issues based on any affidavit and memoranda filed by the parties. The court denies petitioner's request and will decide the Rule 6.1 motion on the affidavit and memorandum filed by the parties, as well as those items on the docket of which this court takes judicial notice. Number 3, analysis of cause for change of judge. A party seeking a change of judge for cause must establish grounds by affidavit. Rule 6.1a of the Arizona Laws Family Procedure, on the ground which may be alleged for change of judge is that the party filing the affidavit has cause to believe and does believe that on account of bias, prejudice, or interest of the judge he cannot obtain a fair and impartial trial. ARS 12409b5. The sufficiency of any cause to believe must be determined by an objective standard, not by reference to the affiant's subject belief. Rule 6.1d5 of the Arizona Rules of Family Law and Procedure. Not based on a belief, not based on a hunch, objective standards. No speculating. Case law instructs that in Arizona, a party challenging a trial judge's impartiality must overcome the presumption that trial judges are free of bias and prejudice. Stagecoach Trials versus the City of Benson. That was Arizona in 2013, quoting Simon and Maricopa in Arizona in 2010. Judicial rulings alone do not support a finding of bias or partiality without a shown of extrajudicial source of bias or a deep-seated favoritism. A change of judge for cause is not warranted if based merely on speculation, suspicion, apprehension, or imagination. Yeah. Well, Gingras and Owens live in a state of imagination. ID, internal punctuation and citations omitted. Instead, the party seeking to notice the judge for cause must prove bias or prejudice by preponderance of the evidence. Quoting State v. Carver, an Arizona case in 1989. See also Rule 6.1d4 of the Arizona Rules of Family Law and Procedure. The presiding judge must decide the issues by preponderance of the evidence. The court will separately consider petitioner's two claims of bias or prejudice. So she's going to look at them. And they need to be a preponderance of the evidence, and they cannot be based on speculation, suspicion, apprehension, or imagination. So A, allegation of independent investigation by Judge Mata. Petitioner correctly points out that Judge Mata's ruling, or July 17th ruling, contains a factual error, i.e. the transcript from June 10th hearing shows that Dr. Samantha Deans did not testify that Planned Parenthood is not open on Sundays. See Exhibit E to affidavit. Judicial rulings alone almost never constitute a valid basis for bias or partiality motion. State v. Ellison, which is Arizona 2006, quoting LoudLilDucky versus United States from 1994. This factual error can be corrected, though, a post-trial motion or appellate proceeding. It does not, standing alone, indicate bias. Stagecoach Trails versus the City of Benson. To demonstrate bias, petitioner asks the court, Rule 6.1, motion at 7, to infer that Judge Mata's erroneous finding constitutes irrefutable evidence that she performed a secret, air quotes, undisclosed investigation into the facts of the matter. Affidavit of paragraph 93, and copied the finding from post on social media, ID paragraph 85. In support of this position, the affidavit includes snippets of June 10th, 2024, comment on petitioner's counsel's website. Planned Parenthood isn't even open on Sunday in LA, and comment posted by an anonymous Twitter user on June 10th, 2024 at 5:08 p.m. It was a Sunday, and all LA Planned Parenthood locations are closed on a Sunday. Identification at paragraphs 90 and 92 of the affidavit. All right, continuing on. The court finds petitioner relies on mere speculation and suspicion when alleging that Judge Mata engaged in a secret undisclosed investigation, air quotes, and therefore is biased. The record evidence reflects conflicting testimony about the day, date, and location that petitioner obtained an ultrasound admitted as Exhibit B28, which petitioner admitted to altering. Petitioner testified that when she was in California on a weekend, she had an ultrasound done under a fake name at a Planned Parenthood. See Exhibit E, 17 minutes, or 17:20 through 19:08. Before trial, petitioner had provided a declaration stating that the ultrasound occurred on July 2nd, 2023. At trial, she changed her testimony to say it was an unspecified weekend in late June 2023. ID petitioner further testified that she had altered the ultrasound to reflect the incorrect date of July 7th, 2023, and the incorrect provider, Smile, instead of Planned Parenthood. See at 55:19 through 58:21. So she has now looked into this. Dr. Deans testified that she had reviewed an ultrasound and available medical records to prepare a report, admitted as Exhibit B41. Dr. Deans expressed concern about the legitimacy of petitioner's medical records. See from 112.5 to 114.23. Dr. Deans confirmed that Planned Parenthood national guidelines require identification at the time of the visit to confirm the identity of a patient. The patient can't be seen anonymously. See at 112.20 through 113.6. Dr. Dean's testimony did not address which days of the week that Planned Parenthood offices were opened. Based on the foregoing, the court finds that when determined by an objective standard, not by reference to an affiant's subjected belief, Rule 6.1d5 of the Arizona Rules of Family Law and Procedure, petitioner has failed to show by a preponderance of the evidence that Judge Mata's finding that Planned Parenthood is not open on Sundays reflects bias or prejudice against the petitioner. Moreover, although not dispositive of the issue, the court further finds that this singular factual finding is of little to no importance given the rest of the findings on the July 17th ruling. That is such a minor thing in the ruling that is not enough. That is a harmless error, not harmful. Like, even if this is true, it doesn't change the ruling. This is not what the ruling was solely based on, nor is it the full thing of why the ruling would even be given. B. Allegations of improper ex parte communication with Harry Howe. Petitioner alleges that Judge Mata's father, Harry Howe, was present in the overflow room during the trial and spoke with several of respondents' supporters. Yeah, not the cult. Supporters during and after the trial. See affidavit paragraph 66. Petitioner's counsel admits the mere fact that Judge Mata's father attended trial, if true, is not the primary concern. Okay. See paragraph 68. For purposes of deciding the Rule 6.1 motion, this court accepts these allegations as true and finds that if they occurred, was not improper for Judge Mata's father to attend a public trial as a spectator and to speak with courtroom observers. Yeah, he can talk to other people. Petitioner asked this court to infer that various statements made by courtroom observers about Mr. Howe confirm that Judge Mata was biased and prejudiced against petitioner. Petitioner's counsel acknowledges this is that his personal view, based on the past several months, is that Clayton's followers are generally not honest or reliable. See paragraph 73. Nevertheless, petitioner's counsel asked this court to find that an edited compilation of these individual comments about Judge Mata's father are clear extrajudicial evidence, showing that Judge Mata had a hostile feeling or spirit of ill will or undue friendship or favoritism towards one of the litigants, i.e. respondent. Rule 6.1 motion at 1314. Applying an objective standard not by reference to the affiant's subjective belief, Rule 6.1d5 of the Arizona Rules of Family Law Procedure, the court carefully reviewed the compilation CD and considered in context each of the comments identified in petitioner counsel's affidavit. Given the seriousness of the allegations, the court has made best efforts to provide both the context and verbatim language of the various statements through, admittedly, the audio of the compilation CD is very difficult to understand at times. Number 1. So now we're going to go into breaking down these statements, and the CD wasn't the best. Statements by Hava Darby. Petitioner alleges that Miss Darby, who speaks between 0 and 40 seconds in the compilation CD, also made statements which appears to imply that Judge Mata told her father that she intended to rule in favor of Clayton before the case was tried. Affidavit at paragraph 69. The first video clip on the compilation CD depicts a virtual meeting among 9 participants with screen names, including one woman with the screen name Hava Darby. Miss Darby holds up her phone and makes the following statement. I ran into Judge Mata's dad in the parking lot afterwards, and I asked him, like, well, what do you think? He was like, I gotta show you something. Female voice, what? So he whips out these papers in his hand, and did anybody... I haven't been online really today, but did anybody... I saw kind of briefly that it was denied. This request for finding of fact, the conclusions of law proposed findings. Male voice, that wasn't denied. That was not denied? Okay, so anyway, did anybody get a copy of this, he was saying? Julie told me that this is just you, Dad, you got to read this, and printed a copy unintelligible. Like, they couldn't understand it. Like, that's a bunch of mumbo jumbo is what that is. Oh, Dad, you've got to read this. Okay. For the purposes of deciding the Rules 6.1 motion, this court accepts that the scenario recounted by Miss Derby might have occurred through Miss Derby. Appears not to be clear as to exactly what she is talking about. This court finds that the fact that the trial judge might have told a family member that she was presiding over a case and might have provided a copy of a publicly available filing. Thank you for stating the obvious, Judge Fisk, because apparently Gingras doesn't understand that. The request for finding of fact and conclusions of law and proposed findings filed June 3rd, 2024, neither proves by a preponderance of the evidence that the judge was biased or prejudiced, nor proves that she told her family member how she intended to rule before the case was tried. Yeah, that's not what any of that says. Where is that? Like, I really thought you might have something more than that from her, the way you were sounding in your little letters. But this is what it is? Oh, that's a copy. Oh, it was denied? No, that was not denied. Okay, like, what in... Oh my God, this is ridiculous. So ridiculous. Number 2, statements of Dave Neal and individuals speaking with him. So if you watched Dave Neal and Megan Fox after the trial, you know, he was sitting out there with Bruce the Moose, and they were talking and, you know, catching everybody as they were coming and or leaving court. They had the scones and the stickers and things like that, and they could come up and speak if they wanted to, because Dave Neal did not go inside. And so just a bunch of people coming out and telling Dave Neal about their experience in the courtroom or in the overflow room. So it says petitioner's counsel affidavit further alleges that an individual named Dave Neal made remarks to signal to the person that they should not disclose further information regarding comments they claim to have received from Judge Mata's father, because her believed that they would expose judicial misconduct on bias on Judge Mata's part, requiring a new trial if those facts were exposed. Affidavit paragraph 71. The second video clip on the compilation CD depicts a group of people standing under an awning. The bottom left corner of the screen says Dave Neal Rush Hour Podcast. In the foreground, there are 2 men talking, one in a red shirt and the other in a hat, identified in the affidavit as Dave Neal. So the other one was Reality Steve Carbone. While the 2 men are talking, a woman in a hat approaches and joins their conversation. A woman on the left in a black shirt chimes in, and a second woman on the right in a black shirt follows up. Male in the red shirt. Judge Mata's dad was in the courtroom with us. Dave Neal, which is the male in the hat. Judge Mata's dad? No way. Male in the red shirt. So we're just going to say Reality Steve. It's in the court with inside room where we were. Judge Mata's dad was sitting there. Dave Neal. She did fantastic. Yes, Judge Mata did fantastic. Woman in the hat at 51 seconds, interjecting. I said, Harry, that's really nice you want to be here to support your daughter. He said, oh, no, I've been hearing about this. I'm here for the circus. Group laughs as the woman in the hat walks away. Dave Neal at 59 seconds, chuckling, hold on. We don't need a mistrial. Additional group laughter. Yeah, because it was a joke. Reality Steve, male in the red shirt, we could get him some scones. Dave Neal, yes, scones. 10 seconds of the video deleted per podcast timestamp. Okay, I don't know who deleted that. Woman on the left, she says something inaudible, waiting to get in. Dave Neal, we just heard. One woman on the left, you don't look like the inaudible demographic. How did you hear about this case? Inaudible, my daughter. Dave Neal, there you go. Hey, that's a woman on the left, and he was reading case files. And then she says something inaudible. Dave Neal, I'm sure he was. I mean, he was probably a judge. I feel like it runs in the family. Woman on the right, something inaudible. He did not tell me any information about her thoughts. Female voice, yes, Judge Mata's dad. And I was sitting right next to him. Dave Neal, oh, I'm sure, yeah. Like, he's probably very uncomfortable. I haven't watched it since then. I could go back and rewatch just to see. I mean, y'all could go and rewatch it as well on Dave Neal's channel. Again, for purposes of deciding the Rule 6.1 motion, this court accepts that certain facts recounted by these courtroom observers might have occurred, i.e. Mr. Howe might have informed the observer before the hearing that he had heard about this case from Judge Mata. Mr. Howe might have told an observer he considered the hearing an additional going on to be a circus, and Mr. Howe might have been reviewing paperwork related to the case. When viewed by an objective standard, Mr. Howe's alleged statement and actions do not prove by a preponderance of the evidence that Judge Mata was biased or prejudiced, or that she told her family member how she intended to rule before the case was tried. Yeah, that's saying, hey, Judge Mata's dad was in there. He thought this case was crazy, just like us, guys. Ha ha ha. He had some publicly available documents. That's not a big deal. Court. So, judge continues on. This court also finds that certain statements made by the courtroom observers reflected nothing more than mere conjecture. Like Mr. Neal's statement that Mr. Howe was probably a judge, I feel like it runs in the family. The court further finds that the video reflects that Mr. Neal's remark, we don't need a mistrial after a speaker started walking away, was made in jest. Yeah, it was a joke. He was being a little jester. As evidenced by his and the ongoing onlookers' laughter and his agreement with another bystander that they should get him a scone. Yeah, it was a joke. Like, oh, get him a scone, he's one of us. It was a joke. But Gingras has no sense of humor. The court concurs with petitioner's counsel's subjective belief that respondents' supporters gleefully celebrated Judge Mata's father attending at the hearing, see Rule 6.1 motion at 12, and that the supporters' actions and perhaps even Mr. Howe's alleged actions can be perceived to have made a mockery of these proceedings. This court declines, however, to impute bias or prejudice to Judge Mata based on statements made by respondent supporters, whom petitioner's counsel characterize as generally not honest. Yeah, he doesn't think any of them are honest. So why should we believe them? Which Ian Runkle pointed out. Like, you're calling them liars, but at the same time, you're like, believe them. Which is it? You can't have it both ways. Generally honest or reliable. Affidavit paragraph 73 about Judge Mata's father, or even statements made by Judge Mata's father himself. It is ordered denying petitioner's motion for change of judge for cause. You do not get a new judge. It is further ordered denying respondent's request for leave to file a supplemental affidavit of attorney's fees and costs. You're not getting any money. You will pay the money, just like Judge Mata said. It is further ordered denying respondent's request for this court to enter further orders pursuant to Rule 8.2a of the Arizona Rules of Professional Conduct. They're not doing anything else with this. They made their ruling. They're not going to make any further rulings. It is further ordered returning this matter to the Honorable Judge Mata to rule on all pending post-trial motions. So she will resubmit the ruling that she already did, that she withdrew. It'll get put back out there and everything. And then she will rule on Owens and Gingriss's motion complaining about having to pay money. Now, just because maybe the amount gets lowered than what Woodnick submitted doesn't mean that she's not going to still be paying money. She's going to be paying attorney's fees and costs, period. And then she's going to need to find, hopefully, somebody to represent her in the criminal matter. Gingriss says he's not going to be representing her in that. It is not his forte, I guess. So that is the court's order, and Judge Rhonda Fisk's ruling on a motion for a new trial and a new judge. She does not think that is needed, and there's no evidence beyond speculation, belief, imagination that the things that he is accusing people of, there's just nothing concrete. And we've known that. But Gingriss calls us stupid on the law and things like that. No, I think most of us have a pretty good grasp on reality. And for those that don't have an understanding of the law, well, this is how we learn. We go over court filings. We learn about court terminology. We can listen to lawyers and things like that. We can learn by watching and reading and listening to all these different things. It also doesn't take a whole lot of common sense to understand that if you don't have things that are concrete, it just doesn't matter in the court of law. And even in criminal cases, it's not about whether they did it or not. It's about, can you prove that they did it? Because just because you can't prove they did it doesn't mean they didn't do it. And in the court, you have to have proof showing that this is how it is. And Gingriss and Owens just don't have that. We are going to end with our quote of the day. And this is from somebody on Twitter. And it says, some people are really so delusional that they think it's disrespectful when you don't just sit back and allow them to continue to disrespect you. And that is Owens and Gingriss for sure. Maraschini, Gillespie, Echard, they are not going to allow Owens to continue to disrespect, defame, and lie on them anymore. It's just not happening. Woodnick, same thing. And then Owens also thinks it's disrespectful when people call out the truth. She doesn't like the umbrella guy. She doesn't like Megan doing it. She doesn't like Dave Neal doing it. Lauren Knighty. It doesn't matter whether you like it or not. It is not disrespectful to tell the truth. You may not like it, but you were disrespectful by doing the actions that you did, and now you have to face the consequences. Do not let people to disrespect you. We are also going to be starting a new series soon, and it is going to be called Migrating True Crime Through the U.S. And it's going to be in a storytelling fashion about these cases. We are going to hit all 50 states first, then we may hit some of the territories, and then we'll see where we go from here. But the 50 episodes are migrating true crime in the U.S. And if you have true crime cases that are pretty much settled, they either have a conclusion or they might be cold and there just isn't any information continuing. I don't want recent cases because these are going to be one episode cases for each of the states. It's going to be about one a week while we migrate through this. There will be merch that's coming. I am expecting to launch it between now and Monday. Hopefully we have some shirts, maybe some stickers and stuff that y'all can order if you want to support this channel. You can also support this channel by liking, subscribing, commenting down below. Those are free ways to support the channel, sharing this out to get more eyes on these things. And we also have memberships if you want to support that way. But that is going to be it for us, and I will see you in the next one. Bye.